Hello, and welcome to this episode of the Diary of a Lawyer. And I just want to quickly cover the new ruling of the European Court of Human Rights regarding the famous runner, athlete from South Africa known as Semenya. Now, Semenya had a victory over the Swiss, where the European Court of Human Rights found that Semenya's rights under Article 14 of the European Convention on Human Rights, which concern discrimination, had been violated by Switzerland. As a brief background, the World Athletic Body, despite the ruling, say that the rules were introduced to protect fair competition into the female category and will remain in place despite the ruling that Caster Semenya had been treated unfairly by the Swiss legal system. Now, Semenya, who is a double Olympic champion over 800 meters, has been unable to compete as she refuses to comply with the World Health Athletics regulations that force her to take testosterone-reducing medication because she was born with differences of sexual development, also known as DSD. The 32-year-old filed a case against the government of Switzerland for not protecting her rights when she was contesting the DSD rules through the Swiss courts. Now, under the regulations introduced in 2018, athletes with DSD were allowed to compete in track events between 400 meters and the mile only if they underwent treatment to suppress the testosterone. However, since March, the rules brought in by the World Athletics require any relevant athletes to reduce their testosterone levels below a limit of 2.5 nmol/L for a minimum of 24 months to compete internationally in the female category in any event. Semenya had twice tried and failed to overturn the rules. First, the Court of Arbitration for Sport, and then the Swiss Supreme Court 3 years ago. The South African's appeal was not against World Athletics, but the Swiss government with the ECHR concluding that Semenya had not been protected from being discriminated against when the Swiss Supreme Court refused to overturn a decision by the CAS to uphold the World Athletic rules. Now, as mentioned earlier, the ECHR found that her rights under Article 14, which are associated with discrimination, had been violated by the Swiss, and the Swiss state was also found to have violated Article 13 in not providing Semenya effective remedy against discrimination. I've covered on another episode the ECR in brief on the various articles, which is down below. Now, the court statements read that the court found in particular that the applicant had not been afforded sufficient institutional and procedural safeguards in Switzerland to allow her to have her complaints examined effectively, especially since her complaints concerns substantial and credible claims of discrimination as a result of her increased testosterone level caused by differences of sex development. The statement added, however, the court was unable to determine whether the DSD regulations, as applied in the applicant's case, would be considered a measure that was objective and proportionate to the aim pursued. It is hard, according to observers and various major observers, they say that it's hard to see that this as a victory for Semenya against her sport because the ECHR does not have jurisdiction over the World Athletics rules, and its decision will not suddenly lead to Semenya returning to competition. I think that's something that needs to be examined in terms of legal terms and how to submit to jurisdiction or have jurisdiction over essentially what is a world private organization that is not a state. Now, the 7-strong ECHR panel was split in 4-3 in favor of Semenya, with the World Athletics noting how it was deeply divided and stating that it will ask the Swiss government to refer the case to the ECHR's Grand Chamber for final and definitive decision, which is one of the procedural and substantive requirements in the process. The statement from the World Athletics remain of the view that the DSD regulations are a necessary, reasonable, and proportionate means of protecting fair competition in the female category, as the Court of Arbitration for Sport and Swiss Federal Tribunal both found after detailed and expert assessment of the evidence. End of statement. So there we are. I think the applicant Semenya went for the state because he has jurisdiction over there as opposed to the actual body. But I think what is interesting is how, if this is in fact a violation of human rights, which is, they're universal, they cannot be taken or removed by any individual, human being, or any organization, how such jurisdiction can be exercised over the World Athletics, given that the ruling is in fact relating to human rights breaches. And so that's where we shall leave it, this episode of the Diary of a Lawyer. Thanks for listening. Let's speak again.